We thank you so much for watching Voices of the Bar, where the legal world speaks. We want to discuss, to summarize, offer, invitation to treat, and then we do some bit of consideration to add a meaning to some of these words. We know that when you are in first year, you come across some of the first things you come across: invitation to treat, offer, and then consideration. Then from there, of course, we shall put cases on offer and then cases on invitation to treat, and we shall discuss some cases on consideration. So let's straight enter into offer, but we ask you to subscribe. Don't watch minus subscribing to our videos, or to our channel. Sorry, we also run two channels: Law School Made Easy and Voices of the Bar, where we are right now. So let's now dig into offer. When you are in first year, you come across offer. But the first thing, if you are asked a question about offer, that should come into your head is that offer has been defined in Section 1 of the Contracts Act. So you begin by citing the that Section 1 defines an offer, because by far this is the first thing we do. That when you are given terminologies, you first have to explain them. What do those terminologies mean? And then you can now move forward. So the first thing you do is to explain offer, that Section 1 of the Contracts Act defines an offer as a willingness to do. Now, it is a willingness. Somebody is willing to do something, to offer something. So after you have discussed it, then now you can enter into the nitty-gritties of what offer means. But of course, you begin with the Contracts Act, because when it comes to contract, the mother law, when it comes to contract, is Contracts Act. Now, Section 2 of the Contracts Act tells you on what entails communication of an offer. One, if you want to appreciate offer, you must first have vivid examples within you that an offer, there must be someone who is making an offer. And when you make that offer, you expect there should be somebody who will take on the offer, or accept the offer, or reject the offer. So meaning that the person who makes the offer is the offerer. So the offerer will make an offer, and they expect someone to take it on, to appreciate it. They actually expect someone to respond to their offer. So communication of offer is made by an act or omission. That you can, it is by an act, maybe by speaking, maybe through adverts. Those are some of the ways you can make an offer to someone. And when you make an offer, the issue is you expect someone to either accept it or reject it. How they accept the offer, that is for another day. But an offer is made through an act or omission. Now, an offer is made complete under Section 3. An offer, close subsection 1, an offer is made complete when it is brought to the attention of the other person. The moment you bring it to the attention of the offeree, then your offer has been complete. You have made a complete offer. That one, you communicated an offer and you made sure it is directed to someone. If I am offering, for example, to sell my phone, this phone is mine. I'm offering to sell my phone. Now, the moment I say I'm selling this phone, I must be communicating to someone. I must be telling a colleague that side, Ambrose, that Ambrose, look here, I'm selling this phone. Now, I have brought to the attention of Ambrose that I'm selling the phone. So my offer is complete to Ambrose. So you now await what Ambrose responds. What Ambrose responds will now take us to acceptance. That is for another day. But we're now discussing offer. So an offer is complete when you bring it to the attention of the other person. Then another very important issue is you can still make an offer and revoke it and stop it for as long as you stop it before the other person responds to you. Then the offer has been stopped. That is under section 4, clause 1 of the Contracts Act. I start to be guided that an offer, when it is actually made, you can revoke it before it is reaches or before you get the response of the offeree. That's the only time you can revoke the offer. So let's look at where the offer is in the case of Karil and the carbonic smoke ball. They put up an advert. Now, their communication was through advert of the offer, was through an advert. And they put up an advert. Their advert was not directed to anyone in particular, but at court ruled that it was directed to the whole world. Their offer was directed to the whole world. So they said, whoever comes up and buys and uses this carbonic smoke ball in the prescribed manner, 3 days, for 2 weeks, will not catch influenza. If they catch, a reward awaits them. So where we have an offer, there is whoever makes, whoever buys. So that was now their offer. Whoever buys, they push the offer to the whole world by saying whoever buys, the offer is made. So meaning that in this case, whoever comes up and buys has accepted the offer. The difference in this case is that we are saying under the Contracts Act that offer is complete when you bring it to the attention of the offeree. Okay, that's when it is complete. You must bring it to the attention of the offeree. But now, in carbonic smoke ball, for them, their offer was open, and that's what we call unilateral offer. It comes from one person to very many people, to the whole world. So that is what we call unilateral offer and offer. So that is where offer was in that case. Now, then when we are discussing an offer, in most times we want to relate it to invitation to trade. But before I go there, let me discuss the counter offer. That under offer, there is what we call counter offer. A counter offer means that a counter offer rejects the original offer, puts an end to original offer. For example, if I say I'm selling this phone to Mariam, and I'm selling this phone 20,000 to Mariam. Then I tell her this phone is for 20,000, and then Mariam says I'm giving you 15. It means that she has countered my offer. Now my offer, the original offer, no longer exists. We are now at 15,000. That's what we mean by counter offer. It automatically cancels the original offer. It automatically cancels the original offer, and now we have the new offer which has been set. Of course, there are implications. As we study, I'll do a video about counter offer, and we'll see all the implications. We look at those cases, Teen Hoffman, and then we discuss those cases, what we mean by offer in that counter offer in that line. So that is, but normally for starters, they normally relate counter offer, offer to invitation to treat. We are saying in offer, somebody is willing to do something, to offer my phone. I am the offerer. But now there's a difference between offer and invitation to treat. Now, invitation to treat is the willingness to initiate negotiation. That an invitation to treat is the willingness to initiate negotiations. Okay. For example, examples of offers include display of goods in supermarket, display of goods, supermarkets. Those are invitation to treat. They are calling you, inviting you. You come and we negotiate. Okay, they invite you, come and we negotiate. So invitation to treat is different from an offer. An offer is made, but here we are calling you, you come and we negotiate under the invitation to treat. Let's give an example. Have you gone to a supermarket before as an individual? Then you see, let's say in the fridge, you see bottles of soda, Coca-Cola. Then you come and say, you come and pick one, you go to the counter. You tell the counter lady, this Coke is 1.5. You tell her 1.5. She tells you, no, 2,000. Who has made the offer? That's the question. Now, under invitation to treat, the person who invites you to the invitation to treat is the one who makes the offer. You who has entered that shop, you don't make the offer. The person who invited you is the one that makes the offer. That for you, you come, we have put our goods in the shelves, you come and look at one, you go and pick it, you come to the counter. You ask how much, I tell you 10,000. So it is me, the person who initiated the invitation to treat, who makes the offer. You understand? Under offer, I wake up and say, I have made the offer, I'm selling my phone. But if I place this phone in the shelves, there is no offer. Actually, the offer is not made at the shelves. The offer is made at the counter. So you come, you go to the shelf, you pick the phone, you now move to the counter. When you get to the counter, that's where the offer is made. And the person who initiated the invitation to treat, the person who set up the shop, is the person that makes the offer. That is the difference. An invitation to treat is not binding on someone, whereas an offer can be binding on someone, but invitation to treat is not binding. Because here we are only calling you, you come and we negotiate. Let's take an example. Let's take an example of the case of Harris versus Nickerson. So Nickerson put up an advert advertising things which were going to be at the auction, saying this phone will be there, iPhone 19, iPhone, all those things, this fridge, cooker, hot plate, sijui, all those things. Then Harris saw and said, I'll go on Sunday, on the day they have advertised, I will go and I buy a particular commodity, this commodity. So when Harris reached the auctioning, he found that the commodities he had come to buy, the ones they were advertising, were not there. So he said, Nickerson, you have wasted my time. I came to buy this. He went to court saying that they wasted my time. They made an offer that these things are going to be there. I have reached there. The things are not there. So court ruled and said that the advert made by Nickerson was an invitation to treat, not an offer. That they were only inviting them to come and they negotiate. It was not an offer per se. It was an invitation to treat. We call you to come and negotiate. It cannot be binding on someone. But an offer is binding on someone. Okay? Let's take a case which clearly explains what we mean by invitation to treat. We have a case of Fisher versus Bell. Bell versus Fisher Bell. In Fisher versus Bell, they displayed a flick knife. And by the laws at the time, the Weapons Act 1850 something, I'm forgetting the year, they were not accepted to display those weapons on the display. So Fisher came and wanted to buy, but they said you cannot access such. Of course, by terms of the Weapons Act and Sijui, and then Fisher went to court, but court ruled that yes, whereas there was a law which whereas there was a law which prohibits uh, the fake knife to be displayed, but it was an invitation to treat. So amount, it couldn't in any way amount to, it couldn't in any way amount to an offer that somebody would be actually charged. Okay. So that is, and then another good case is Great Britain Pharmaceuticals versus Boots Chemist. Versus Boots Chemist. That is another very good case. That in this case they were selling drugs, but some drugs were not allowed to be sold. But the pharmaceutical, the Boots Chemist, they had brought somebody qualified who would sort them from the counter. So when they went to the counter to get the drug, for them they thought that the offer is made at the counter, so they sued. But here at the counter, sorry, they thought the offer would be made at the shelves, but yet at the counter there was somebody qualified to check, not to allow the buying of those chemicals. So court ruled that an offer, sorry, that the display of goods is just an invitation to treat, not an offer. An offer is made at the counter, and at the counter there was someone who would advise whether to buy those chemicals or not to buy them. So meaning that the Great Britain Pharmaceuticals could not succeed under that case. But all in all, what we have in this case is just one: that invitation to treat is not an offer, it is just an invitation for you to come and you begin negotiation. And second, the offer is not made at the shops, but offer is made at the counter. The person who brings the offer, uh, the person who initiates the invitation to treat is the one that actually makes the offer. Two, let's now cross to consideration. Let's now cross to consideration. Now, consideration is still, you now cross to section, you cross to section 1 of the Contracts Act, which defines it as the interest, benefit, profit accruing to forbearance, detriment, loss undertaken or suffered by another party. Then, colleagues, you cannot discuss consideration minus discussing the case of Churi versus Misa, because the definition you have in section 1 was the holding in Churi versus Misa. In Churi versus Misa, the holding of Churi versus Misa is the definition you have in the Contracts Act of consideration. But let me give you an analogy before I go to the types of consideration. What is consideration? Consideration, for example, if you take an example of my phone, if I go to the shop and I buy a phone from the shop, the people of the phone, or of the shop, sorry, they have lost a phone, but they have gained money. I have lost money, I have gained a phone. That is consideration. Loss and benefit. Profit accruing to one party. That there must be loss and benefit on both parties. That if I'm selling my land to Muonge, if I am selling my land to Muonge, okay? Now, Muonge gives me money, I tell him this land is now yours. So Muonge has lost money but has gained land. I have lost land, but I have gained money, loss and benefit on one party. So both parties suffer loss and benefit. I give you my phone, you give me money. So I have lost my phone, but I have gained money. You have lost money, but you have gained. So that is what we call consideration. Okay, that's what we call consideration. Now, consideration takes three types. There are three types. There is executed consideration, executory consideration, and there is past consideration. I want to ask everybody to go on Law School Made Easy and you look up for a video of consideration where I have discussed the three, uh, where I have discussed the three. But I'll put emphasis here on past consideration because that is where they normally want to ask. Now, past consideration is not good consideration. Actually, if I ask you what is past consideration, you can say past consideration is no good consideration. That, for example, if you look at the case of Rimakado case, before I go to the case, under consideration, under past consideration, the issue is very simple. If you go and you do something minus informing me, and then you come later after you have done it, you tell me, I did this, please give me some money. Your claim is in past consideration. Because under consideration, you must give, I give. We lose at the same time. You have done something in the past, but again, you want me to pay you. It cannot be. Take an example. If I leave my car here at home, I leave my car in the compound here, I go, let's say, outside the country for 2 weeks. When I come back, I find that one of our neighbors has washed my car very well and is saying I should give him 20,000. I may accept. But if I don't give him, he cannot report me anywhere. Because what he's asking for is past consideration. There was nothing me I gave. I never told him to do it for me. So there was no consideration. So past consideration is no consideration. Okay? So I want to ask you to the case of Rimakado. It will clear the explain and you know what we mean by past consideration. This lady, uh, one of the wife of the children at home, renovated the house minus informing these people. But then later, they told her they will pay her. So they failed to pay. She wanted to report. So court ruled that her renovation was in the past. Consideration is in this form that I tell you, do this, I do this. Where you come and you do minus getting my consent, you can't come and claim later. That is what we mean by consideration. But I want to ask everyone to go on Law School Made Easy. There is a video there about consideration and the types of consideration, where I have able to discuss the three types of consideration. And then you see, but of course, in the future, I am going to able to discuss all the elements of consideration. Of course, there is already part payment, Pino's case, all those things are already discussed on Law School Made Easy. So we thank you so much for watching Law School Voices of the Bar. Subscribe, share, like our videos. Until next time, thank you so much.